And Your Honor, how can this be a court of record, a criminal case, if there is no verified complaint by a living injured party?
Why wouldn't I be released back into the community? Because honestly, I'm immune. I'm sovereign. I'm a sovereign citizen.
I got you.
I'm sorry, sir, who are you?
My name is Dustin Anthony of the House of Kaminsky.
I see. Thank you, Mr. Kaminsky.
I apologize. My clippers died halfway through a haircut. I could put my hat on if it pleases the court.
It's okay. Thank you. I'm just happy that you appeared. Court will recall 26 CR6. People v. Dustin Kaminsky. He was on a PR bond and appears. This case will be set for filing of charges. Were charges filed? Thank you. Did you have you received the charges? Nope. Okay, give us just.
I don't think charges were filed on this one.
Okay.
Sorry, whoever made the case didn't hide them, so they looked filed online.
Oh, okay. So there will be some filing of charges. That will be next Tuesday, March 24th. So you'll have to come back here March 24th at 1:30 here at the jail, okay?
Okay.
And then the district attorney's office will, because at this point you are accused of a crime, you were arrested, but then the district attorney's office has to file the official charges against you.
Okay.
And so you'll need to return back here March 24th at 1:30, and you'll remain on bond, and unless you fail to appear, then that bond could be revoked. So that's the paperwork, and you'll need to come back for the filing of charges. And then if you are looking to have the public defender's office represent you, you'll have to apply for their services, okay?
Okay. So since the files haven't been charges haven't been filed yet, I can't inquire against what the nature and cause of the case against me is.
Well, you were arrested on January 2nd. 2026, and so that's what the charges arose out of.
Okay. Is this a criminal court or is this a civil matter?
This is a criminal matter.
Okay. I'm here by special appearance. I'd like to challenge, subject matter jurisdiction and personal jurisdiction.
Yeah, this isn't the time to do that.
Okay.
but
That's
we-
why I asked
but-
about, this filing of charges yet.
Yes, and so we will address that, but not at this time.
Okay. And that was the 26th at what time?
No, it's the 24th, March 24th at 1:30.
Okay.
Yep.
Take
and
your
the
time,
piece-
thank you.
And the piece of paper that you have has that date on it. Do you see it?
This
Why don't
could
you?
help.
Yeah, go ahead. Why don't you put your glasses on and why don't you repeat that date to me?
Yes, March 24th at 1:30 p.m.
Okay, thank you. We'll see you back here at that date and time.
Have a good afternoon.
Thank you, you too.
That's 23 CR 5243, People versus Dustin Kaminsky. Can you hear me, Mr. Kaminsky?
I'm also hard of hearing, but I can hear you, sir.
Okay. All right. Can I have entries?
I'm Dustin Anthony of the House of Kaminsky. I'm here by special appearance to challenge both personal and subject matter jurisdiction.
It looks like you're represented by the public defender. Is that right?
He was at one time, Your Honor. If he wants counsel to be appointed, we can enter today. This would be my first time actually appearing with him if he wants a public defender.
So, Mr. Kaminsky, because you're in custody, you have a right to a public defender if you want one. Would you like me to appoint the public defender?
I can speak for myself, Your Honor, but any help would be also acceptable.
Okay.
I guess then that sounds like a yes. So I will go ahead. And are you Ms. Barton?
I'm Camille Taylor,
Oh, okay.
bar number 48054.
Okay, thank you. And for the people?
Lindsay Maas for the people, Your Honor, attorney registration number 49996.
Okay. And would then this be your case, Ms. Taylor?
It would be, Your Honor.
All right. I will appoint Ms. Taylor on this case. Looks like, is this a first appearance on an arrest warrant?
This is a revocation of probation matter, it looks like. it looks like we need to set bond. It was previously set at $450 cash back in 2024. So, but since he's been arrested this time, we don't have a bond set.
Okay, would you like to be heard on bond?
Yes, please. Given that the prior bond was a cash bond in the amount of 450, I would ask for a slight increase to 475 cash.
Okay.
I would
Anything
ask
from-
for a PR bond, Your Honor. I don't have any cash on me.
Okay, well,
Alternatively, a PR.
so Mr. Kaminsky, here's the thing. If you have the public defender representing you, they speak for you. Okay?
Well, then I can speak for myself, Your Honor.
Okay, well, let's hear from the people.
Thank you, Your Honor. The people are recommending a $600 cash-only bond. We'd note for the court that Mr. Kaminsky was initially on a probation revocation summons. He showed up for his first court date several hours late, avoiding a warrant at that point. He failed to appear at his next appearance, and it would seem that while on failure to appear status, Mr. Kaminsky has picked up an additional felony case in Boulder County. We do believe that the increased cash bond value is appropriate based on the failure to appear as well as the other records made by the people. Thank you, Your Honor.
Your Honor, that felony case out of Boulder County was dismissed, and they also entered a motion to quash the record, the arrest record, and it was signed by the judge in Boulder County.
Okay, well,
So there
if
is no felony case out of Boulder County at this time, sir.
All right. Even assuming that that is true, I'm going to find, based on the failures to appear in the history of this case, that a cash bond is appropriate. I'm going to set bond at $500 cash only, with all original terms and conditions. Okay, there's been a complaint filed by the probation department. I find that that's appropriate, and that this is a court of record for that purpose.
And then, Mr. Kaminsky, you have the right to a revocation hearing within 14 days of today if you want to set immediately. That would be an evidentiary hearing where the prosecutor would have the burden to prove that it's more likely than not that you didn't comply with your probation. So you could set that today immediately, and the judge would have a 14-day timeline in which to hold that hearing. Otherwise, you could waive the 14 days and set that hearing literally any time, whether you're in custody or out. I would rather meet with you to discuss the allegations before we set a hearing, which would require you to waive the 14 days. Are you okay with taking that approach?
I don't have the $500 cash on hand, so I'd rather just take care of this right now.
We can't, either way, we're not taking care of this today just because I haven't talked to the DA about a plea offer, and I don't even have a copy of the complaint against you.
Okay, I completed treatment. I completed
But
the
Mr. Kaminsky,
class that
we're
was
not-
required.
Mr. Kaminsky, don't talk about the facts. So I'm going to chat with him if that's okay, counsel.
That's fine.
So, Mr. Kaminsky, as your attorney told you, you have a right to a hearing on the complaint. Because you're in custody, you have a right to that hearing within 14 days. If that's what you want, we will set a hearing for you. Your attorney would like some time to talk to you and see if she can reach an agreement with the DA. That may take more than 14 days, and that's how this is typically handled. If you want her to try to do that, you would have to waive your right to a hearing within 14 days. We'd set a status conference at a time that the attorneys agree to, and if you're not able to reach an agreement then, we would set a hearing. So do you want
Well, I
me
don't
to
see
say-
why my attorney couldn't handle this within 14 days and review the evidence and also review with the district attorney. I'm going to be sitting here since I don't have
Okay.
bond. Would the court
All right.
consider a PR bond?
No, I wouldn't.
I would be able to prepare better
Mr.
for this case.
Kaminsky, you need to let me talk now. I'm going to find that he's not willing to waive his right to a hearing within 14 days. We will set a hearing. If the attorneys are able to work something out prior to that hearing, that's great. But if not, we'll give you your hearing within 14 days, okay? Can we
you.
get a date?
How long do you need?
Can we please have an hour, 45 minutes?
I can do August 8th at 2,
August?
or I'm sorry, April 8th at 2.
Does that work for counsel?
April 8th at 2. That'll be fine.
We can accept that, Your Honor.
All right, so Mr. Kaminsky, your hearing is going to be April 8th. That's a week from now, more or less, at 2:00. Your attorney will, I'm sure, try to be in touch with you before that to talk to you about your options and to prepare for a hearing if there's going to be a hearing. Okay?
Okay.
All right, thank you.
Have a good morning.
You too.
Mr. LeBeau?
Yes, Your Honor.
Mr. LeBeau, good afternoon again.
Good afternoon, how's it going?
It's going well, thank you. I wasn't hoping to see you so soon again. I gotta tell you.
Yeah, things happen.
I know it happens. I know. I just was hoping for a time where you and I, not that I mind seeing you, I just wanted you to have some space, you know what I mean? So the case is 26 CR 388, comes on for an advisement. The court does find probable cause. Regarding the bond, Mr. LeBeau, let me hear from the attorneys. Ms. Cunningham?
Judge, we will be requesting a personal recognizance bond with the appropriate conditions. That is what is recommended in the bond application. So we think that is appropriate here, and also given the nature of the charges, it appears to be a lower level felony if I had to guess.
You don't have to guess. DA, bond.
Honor, I am asking for a $5,000 cash or surety bond. I recognize that this isn't, a super aggravated felony case, but I'm definitely concerned about his ability to comply in the community and to return to court. It looks like he has 8 failures to appear in the last 4 years, most recently being 2 weeks ago in the case that he's currently on probation for. So those are my concerns, and I think a secured bond is appropriate.
Your Honor, may I have word?
If you want one, I can tell you this, your attorney probably doesn't want you to speak, but I promise you, I'm not going to stop you if you want to talk briefly.
Well, just directed towards the district attorney, I'm part of the Oklahoma Sioux Tribe, which with Medicine and Wheel Coalition is a coalition with the People's Republic in Boulder County.
Mr.
I know,
Hello?
we've talked about that. You and I have talked about that in my courtroom. I know that.
If they haven't contacted President Starr, comes out, or President Dolan Wood, and why wouldn't I be released back in the community? Because honestly, I'm immune. I'm sovereign. I'm a sovereign citizen.
I got you.
So I don't even know why. I already have hostage and ransom insurance on this claim right now.
I got you.
The incident that happened, I own Wells Fargo. My grandpa's the owner of Wells Fargo.
I got you, Mr. LeBeau, and I've heard some of those things, not all of those, but some of those before. And while I do want you to speak, if you want to speak, I got to tell you straight up, it's not helping the case right now. It's not a useful thing right now. You know what I mean? I'm going to set bond as follows: $5,000 cash or surety. Conditions: no contact with alleged victim. Pretrial supervision via CJS. Report to your Boulder County probation officer within 24 hours of bonding out. No drugs, no weapons. Stay away from Street, Boulder. Filing of charges Friday, April 3, 1:30 p.m. Right back here. We'll see what charges the DA chooses to file, if any,
Who's the victim, though?
in the case. Thank you, Mr. LeBeau. We'll see you in 2 days.
Who's the victim